rise. District Court P79 is now in session. You may be seated.
We should be able to connect, right?
Oh, I just connected by reconnected, so,
Okay.
listen. Anything on that?
Right. There it is. Good work. You're doing great. Do we have docket sheets for? Yeah, we're gonna need some docket sheets.
They're bringing them up.
Okay.
Indictments, but they're not in here because it's before us. So they tell you which motions. Do you know which motions? No? Do we know which motions we're gonna, John, can you tell me which motions we're going on?
Can I approach so I can hear you then?
Can you tell me which motions?
We filed 3 motions in limine
For the limine?
today,
Okay.
right?
Okay.
We received a motion in limine, 2 motions in limine from the defense, and a motion for judicial notice. I don't know if there's any other hearings.
So state has to run, okay.
And then I got, this was just delivered to me, these proposed jury questionnaires. I guess is this one
Well,
to say?
Your Honor, it was tendered to the court and defense at our last hearing in April, and we had heard that it may have been misplaced, and I dropped another copy for the bench review this morning.
Okay, so we'll
But
talk
it has
about
been
that.
shared.
Okay.
And there's other concerns that when the motions are concluded that we'd like to bring up to the court.
Okay.
Sure.
Do you have another motion? That's it, just these 3 state limiting motions?
Yes.
And then somebody from the city dropped off this DVD related to a city training course on tactical disengagement. That's something y'all are familiar with?
That's the one we both been passed.
So my understanding is the city wants that under seal.
Yeah, well, we're not gonna get into the arguments now.
Okay.
We're just trying to figure out what it is we're gonna talk about today.
They filed a motion to quash.
You filed a motion to quash.
Jim Kopp with the city came by, dropped it off.
Okay.
He just dropped it off and said that it was related to today's hearing.
Yeah, we filed a motion to quash, but, so we're not, at the appropriate time, we reached an agreement with Mr. Cifuentes regarding when to approach you in the event that it becomes material.
Sounds good.
Do you need
But
that motion?
I'm glad
Yeah, whatever.
Ms. Scipiora is here, Erica Scipiora is here. Because one of our concerns, which we'll bring up later, involves the city and its employees.
Okay, sounds good. Let's just get these, Trish is gonna get the motions out and then we'll figure out where we go from there.
Okay, I have a limine filed by Mr. Christian, we do not?
That's one of the motions, yes.
Okay. And then Which one?
There were three in the, Alpha case on defendant Flores filed, April 29th of 24. And then I just discovered late that they had not been filed in the.
They look like that. There's one
I
for
thought
each,
I have-
in each case.
Oh, like this? Oh.
Yes.
Okay, I have one of those
Okay.
on.
It's gonna be
Alejandra.
the same in each one, but it's on each
Which one?
defendant.
This one. So those, okay. So she has one. You already have, Alejandra. And then. And then this one also? Or no?
Is that one ours?
Mhm.
Oh, is this an old one?
I think so.
Yeah, this is, y'all, yes, this, I think this is the same one, right? But it's
It's
titled
titled
differently. Is this
differently.
one you filed previously?
Yeah, this is in effect, it's one of the same ones from, this is good. It just hadn't been filed in the B case.
See,
Well, this is
this was
the B
filed
case.
today,
Yes.
right? This is one, and you refiled it later? right?
Yes.
This, it was
So-
repeated, it was filed again later because the names didn't match from the order.
Which one are we using?
The later ones.
This one?
Uh-huh.
Okay. So she's
Okay.
gonna print the other ones that look like this.
Yes.
And then, I gave you Christians, right? And then I have one for Mr. Fuentes. You have one, Mr. Fuentes. Eliminate.
I
Hearing none.
didn't see anything on Villalobos, correct?
Yes, we filed that.
Okay, do you want, okay, so this one.
You guys. No motions filed today or yesterday?
There were,
Choose the same.
There were. On the expert, the notice of expert.
This is the state's one. There's gonna be one of these. Okay, let me read the docket sheets.
That came last yesterday too.
No, I need Flores and Lopez. Okay, and they all have that same title, that Graham v. Connor. No, he just filed them yesterday. Oh, where'd you get the ones that you have that one? Oh, you just. Oh, that's me, yesterday. The motion only regarding Graham v. Connor. They also, there's one of those for each case, so the only one we need is the one for Alejandra. So I need it for Flores and, you know, Lopez. Okay.
Is that it? We got everything?
There's gonna be, or you could call, I just call it, because she's just, it's the same motion, it's just for each case number.
Okay.
So she's just bringing the other two case numbers, the one that's for the state. That's the one that's the Graham v. Connor. That's, and that's why, I guess I wanna assume Jay's office doesn't have anything.
Mm-hmm.
But, Mr. Norton, you don't have anything?
I mean, we're adopting the code of conduct.
Gotcha. All right, then, yeah, that's it.
Whenever you're ready.
Ready to,
Y'all ready to rock?
We are?
All right, I'm gonna call the case. 2023 CR 11510A Alfred Flores. 2023 CR 11510B Eliasad Alejandro. And 2023 CR 11510C Nathaniel Villalobos. Here for the state.
David Lunan, Daryl Harris, and Daniel Escobar, for the state.
Defense.
Ben M. Cifuentes Jr. and Mario Del Prado, along with Brian Medina for defendant Alejandro Eleazar. Alejandro.
Nico Levette, Afternoon, Judge Tom Nisbet, Christian Newman, and David Christian on behalf of Alfred Flores.
All right, this is a pretrial hearing. Our voir dire is supposed to begin tomorrow. What do we have?
Your Honor, I think it would be efficient for us to dispense with the state's motion in limine on Graham v. Connor because it impinges upon and is highly relevant to our reasoning why we're requesting the judicial notice be granted of the court opinions and reports in the now dismissed federal litigation over the same factual matters. And when we address the motion in limine Graham v. Connor, you'll understand why judicial notice should be granted and why those opinions should be admitted.
Judge Tom Nisbet, for the record, on behalf of Alfred, I propose we do it this way. We have a series of motions in limine. The defense have filed some, and the state has filed some. Perhaps the court will consider hearing each motion in limine in turn, deciding on a ruling. Then there is a different type of motion on a judicial notice issue filed by the defense. Perhaps the court could hear that next in turn. Then we have a special issue we would like to address with the court as a third item or group on the agenda. And then perhaps off the record, once we've concluded, the defense would like to talk about a couple housekeeping matters with the court, such as what courtrooms we're gonna be in, what the design of those courtrooms is gonna look like. Do we have juror number cards, that kind of general housekeeping thing. And then the other thing we'd like to proffer to the court is, by our joint defense agreement, our proposed order of presentation to the court. Mode and flow that the judge wants to ensure an efficient and not confusing presentation of the evidence with 3 defense teams. So we have our requested proposed defense order that we can put before the court for its consideration as well. It's just a sort of a general agenda.
All right. Well, let's go ahead and begin then with the motions in limine. I guess we'll take up the motion in limine regarding Graham v. Connor, filed by the state.
Yes, Your Honor. And I would say for Sheriff Arden, as Mr. Fuentes pointed out, the state does believe there is some overlap with the state's motion regarding Graham v. Connor and the language and analysis used in the defense motion for notice of a prior decision. Basically, as the state has asserted that we suspect that defendants Flores and Villalobos were charged with murder, aggravated assault, deadly weapon by public servant, manslaughter, and deadly conduct. Flores and Alejandro are charged with murder in the 5 counts indictments, and defendant Villalobos, the Charlie case, is charged with aggravated assault, deadly weapon, and deadly conduct. The state anticipates in trial that the facts, the objective facts on the offenses will not be in dispute between the parties. What will be in dispute is the interpretation, analysis, and the applicable, appropriate law and context with which to evaluate it and to let it be presented to the jury. Texas Penal Code sections, we anticipate that the defendants will rely on sections 932, 933, and 951 of the Texas Penal Code as legal justification for the officer's conduct. Those sections of the Texas Code require the defendants have a reasonable belief that the force is immediately necessary, and a reasonable belief is defined in Texas penal law. Although the defendant may act on appearances as viewed from his standpoint, the test for reasonableness under the Texas Penal Code assumes the ordinary prudent person standard test out of tort law. We anticipate, since the officers were law enforcement officers at the time, they would want to argue that the reasonableness of their force should be judged from the perspective of a reasonable officer on the scene, rather than 20/20 hindsight cited directly from Graham 490th U.S. and 396. We anticipate that the defense will be to tell the jury that police officers are often forced to make split-second judgment decisions in circumstances that are tense, uncertain, rapidly evolving. As those citations make clear, that standard comes out of Graham, which was litigated under the 42 United States Code Section 1983 to recover damages sustained for improper use of force, and particularly Graham out of a mere investigative stop. The source of those rights was the Fourth Amendment right to be free from unreasonable searches and seizures, which explicitly protect a person against overt and intrusive government action. That's the proper context for Graham, but it is not appropriate for this case, because Graham does not address whether or not the defendant's uses of deadly force is a violation of Texas state law. While Graham establishes what the citizen's protection is against unreasonable force under the Fourth Amendment, it does not establish the limits of a police officer's criminal liability under state law on using either deadly or excessive force. It is for those reasons that the state urges the court admonish and limit in reference, and that goes directly to the interpretation of defense's motion in limine because of the civil litigation, which was, the defendant's motion to take judicial notice. Now, our argument to that is based on 3 points. First, in the motion submitted by the defense, they argue the factual scenario which was presented is accurate, and we take several disagreements with that. First off, this encounter started and extended itself over approximately 77 minutes before deadly force was used. At that point in time, the deceased complainant, Melissa Perez, was within her home. Supreme Court law under Payton establishes that the home is where one's Fourth Amendment rights against unreasonable searches and seizures is at its highest. Beyond that, state law under section 14.5 of the Code of Criminal Procedure specifically authorizes an officer may make an arrest without a warrant, except when the arrestee is inside their home, absent consent or an exigency defined as is enumerated in several state decisions, i.e. a risk of escape, a risk of destruction of evidence, harm to someone else inside the home. And the facts in this case negate all of those possible exceptions to the warrant requirement. Specifically, the state expects, and I don't believe there will be a factual dispute, that the initial officers that encountered Ms. Perez, they spoke, she admitted to the criminal mischief offenses. The officer asked her to come with me. She asked, "Are you going to arrest me?" He told her no. Another officer approached, she went into her home. Yes, that officer yelled stop, but she got into her home. And at that point, for approximately 30 minutes, the officers engaged with her. They then decided they're going to write it off. They even shut off body cams. They had left the environment. They then encountered someone, gained information.
I'm going to object to him misstating the evidence, and I would also ask that he limited his argument to the law.
motion that the defense is seeking with the limine cites a civil court decision that inappropriately mischaracterized the evidence in front of that tribunal.
All
I am
right.
simply saying what the evidence will be at play in this case.
All right, so I recognize that this is not an evidentiary hearing, it's a legal
Yes.
argument. So
So-
recognizing that state, you can continue.
So then with that, so the second thing, aside from the wrong standard under Graham, is that were the court to grant such relief, it runs the risk of undue commentary on the evidence, on the weight of the evidence. And for that, I cite 99 Southwest 3rd 604, a Court of Appeals decision from 2003, that when a trial judge takes judicial notice of adjudicated facts, which is what the defense is asking the court to do, to take notice of the civil decision decided on a different standard, and it is the state's position with an incomplete factual record, you're authorizing the finder of fact to accept that truth when it's really going to be the finders of facts decision to determine the truth from the evidence admitted at this trial. And so we would urge the court to grant the state's motion in limine regarding Graham v. Connor, and specifically to deny defense's motion to take notice. And one third point, defendant Villalobos, Charlie case. It's inapplicable to him, he's not a litigant in it. And I noticed by the way they filed it, they're also saying it doesn't apply to defendant Flores. It only appears to be filed in the B case, and Flores, it would be unworkable or unwieldy if you were to try to parse it off for just defendant Alejandro, when Flores has the exact same charges in context.
Right, defense?
Judge Tom Nisbet, under the A case, I guess just initially, to respond to the last argument in turn, I think it was already stated on the record here today, all motions were adopted by the defense party in Cohen and Hull, so I think that's a spurious argument, and I'm not gonna address that any further. Moving back to the Graham v. O'Connor state's motion to exclude it, arguments on behalf of the defense, specifically from Alfred Flores, would be as follows. The first would be, Judge, that's a Supreme Court opinion. That is the highest court of law in the land. And that Supreme Court opinion has informed almost every single law enforcement training protocol and expert analysis in the country of the United States, to include the state's own expert, who talks about it continuously in his report provided in discovery. To exclude the seminal on-point case which establishes the legal standard of totality of the circumstances and viewing the action from the reasonable officer's perspective, i.e. putting yourself in their shoes at that moment, would be a gross deviation from the law as it's designed by the Supreme Court, as it should be implemented in a case like this, case in point, okay? And the court is well aware, and we don't dispute, we're gonna be talking a lot about Chapter 9 over the next 3 or 4 weeks with you, sorry. But under Chapter 9, the standard is that a juror has to place themselves in the shoes of that officer when viewing the danger at that moment in time. That is the same analogous placement that Graham v. O'Connor calls for in using the totality of the circumstances, and it's just inseparable from this type of case. That's our first argument. I think factual issues, not to get down into the facts because the court recognizes the type of hearing, but I think factual issues will show that McManus publicly and in training states Graham v. O'Connor is the cornerstone of their officer training, they implement it at the academy, and they implement it throughout their training protocols. It is very much a part of SAPD. So to say we're gonna turn around and not talk about it in an SAPD case seems double-sided. It's a sword in a shield type argument. Moving next, Judge, to the duration and entry into the home. Opposing counsel, through facts, wants to talk about the length and the basis for the entry into the home. To defense's motion regarding the judicial notice issue. I'd like to keep them separate, but it has to dovetail. And it dovetails like this. State is going to, it seems, persist in their argument it was a violation of the Fourth Amendment. Those were counsel's words. It seems that is going to be a cornerstone of their argument in front of the jury. They're going to try it as a legal proposition, but they're going to try it with facts, and it's going to be a central, critical part of their case and their prosecution, where they try to put my and these other clients, these officers, in prison. And so to have a federal opinion, which has been adopted and duly and properly ratified under the rules, which meets the definition of law under Rule 107, subsection 30 in our state code, that is law. It specifically cites federal opinions. On point, stating there are no civil rights violations here is so relevant and on point, it couldn't get any more relevant, Judge. And if they are going to persist in arguing Fourth Amendment civil rights violations by our clients, then the number one piece of evidence the jury needs to consider is law by our very own legal definitions under 107, that it was not a civil rights violation. That's our base argument for the judicial notice, and then I think these guys have more. But to dispute the law, to combat the law, and then to have a ruling directly on point that falls under the definition of the law is to again try to use a sword and a shield. And Judge, that's just not equitable. It's not fair and it doesn't comply with the law. So we would argue that the federal opinion, based on their representation of where they're going with this case, is relevant and admissible as law. And then we would also argue you cannot separate Graham v. O'Connor from this type of case. If this was a criminal trespass or a shoplifting case, we wouldn't be talking about Graham v. O'Connor. But this is like, you know, trying to take the chocolate chips out of chocolate chip ice cream. It is a central, critical part of it. It is inseparable. So we would argue that the court make a ruling that Graham v. O'Connor be included through expert testimony, through officer training, and through the applicability of the totality of the standards. And then we would make our preliminary ask, although I think there's going to be a lot more argument on it, on the judicial notice. And then I guess, Judge, for our specific motion in limine, do you want me to wait on that until we've kind of resolved this core issue?
Yeah, at the same time, I'm kind of looking at it like, you said it, right? The law is the law. We have no idea what facts are going to come out. I have no concept what these facts are going to present, so it's difficult for me to think about that type of a ruling without having some facts before me, through evidence, right? But yeah, y'all can continue the argument.
Okay, well, our next motion in limine is about a different subject matter than what I'm discussing right now. So I guess what I'm proposing is I'll reserve that for a moment and let counsel finish the argument on this subject matter.
Sounds good.
All right, thanks, Judge.
Okay, Judge, I'm not going to reiterate the points that my colleague made, but I will try to say something helpful here. And the first thing is just, I've confronted this motion in limine before, and I believe Your Honor's even heard it before in a previous case. And the first thing is, it fails to even ask for any specific relief. When I read this, I don't understand what they are asking the court to do here. I mean, this motion will be struck in federal court as insufficiently prayed. So are they asking us not to say the words Graham v. and Connor in that order, not to allude to any of the phraseology within that opinion? I don't know, because the state hasn't specifically prayed for any of that. They're not giving Your Honor the request that you need to actually make an informed decision here. That's my first point. Now, we know that Graham v. O'Connor is taught as part of SAPD's use of force training. We know that. Chief McManus has testified on the record under sworn oath as to that fact. I don't know that the state would even dispute that it's part of their training. And so if they are going to argue or allude that these officers did not act in conformity with their training or with the standards of SAPD, then it becomes directly relevant. Granby O'Connor becomes a direct part of that conversation. Any witness, be it state or defense, that gets up and testifies concerning whether these officers did not act in conformity with training, that is going to be implicated, and that's fair game to be asked about. So limine would be inappropriate there. And the second, I think Tom sort of alluded to this, Graham is naturally aligned with the standard, with the justifications in Chapter 9 of the Texas Penal Code that are going to be implemented. I think Mr. Harris said, and he's correct about this, that those standards in Chapter 9 are adapted from common law tort. Well, so is Granby O'Connor. It's the same standard. Now, it may be applied within the court's application portion of the charge differently, obviously, because the facts are different. But the standard is a reasonable person, that's the objective part, in the defendant's shoes. That's the subjective part. These defendants were all officers on that scene that night acting pursuant to their duties. So it's going to be a reasonable officer standard. And there's no daylight between the Graham standard and the standards of Chapter 9 of the Texas Penal Code that's going to be applied. So it's inappropriate to say other. You can say it's a civil standard all you want, but they're both birthed from the same mother, and there's really no daylight between them. I'll just make the objection that an order in limine on this point would be significantly overbroad. It would be vague because they haven't specifically prayed for what they're asking the court to limine out, and it would be an abrogation of the defendant's right to present the defense as guaranteed by the Sixth Amendment to the United States Constitution and Article 1, Section 10 of the Texas Constitution. And just before I sit down, I don't think I said this on the record, but just to be clear, we are adopting the motions we're hearing today that were filed by our co-defendants. Thank you.
Judge, I think it's important for you to take a look at the indictments in this case. With respect to Eleazar Alejandro and with respect to Alfred Flores, counts 2 through 5 have this language. And the defendant was then and there a public servant acting under color of his employment, namely a San Antonio police officer. Thus, they have put into issue what is reasonable for a San Antonio police officer, suggesting that we can't present evidence that would establish the reasonable belief of a police officer is an offensive use of the motion in limine, and it should be abhorred by this court, and should, on that grounds, it should be denied. The only conceivable way that they could have a colorable argument is if they were to dismiss forthwith counts 4 through 5. And in terms of Patrick Valentine's client, they should have dismissed that case in its entirety if they believe that Graham v. Connor, and it is Connor, not O'Connor, but Connor, is inapplicable. Now, I have for this court a transcript of Chief McManus's testimony in the case of Andrew Vargas versus City of San Antonio. And it's replete with him saying that Graham v. Connor is in the SAPD Cadet Training Manual on the use of force. And he admits that that is the standard. And on the third volume, on pages 507 through 557, he explicitly admits Graham v. Connor applies. Now, if you want a copy, I can provide it, and I can provide a copy to the state. In addition, the TCOL instruction, course ID 2107, says that the Texas Commission on Law Enforcement, in its curriculum, and I can provide this to the court, teaches Graham v. Connor as a standard for the use of force. In addition, that's the intermediate use of force. In addition, the Basic Peace Officer course, Chapter 28, also teaches Graham v. Connor as the standard that police officers must apply, and I can provide that to the court if the court wishes. Now, addition, procedure 501.03C says that the use of force by police officers shall not violate federal laws on excessive force. So the police instruction on how to use force explicitly references federal laws, which is 42 U.S.C. 1983. And the people that interpret 42 U.S.C. 1983 are the Supreme Court of the United States and the United States Western District of Texas. So they have interpreted the law, which is referenced in SAPD procedure 501.03. Now, what's important is that the grand jury, and I realize you are not going to consider evidence, but the grand jury was misled by the state in policy violations, alleged putative policy violations, as being a reason why the use of force was not reasonable. And one of the grand jury presentation was,
First of all, let me just object to a minute, because sharing of things that happen in the grand jury is in violation of Texas Code of Criminal Procedure 20A 205, subject to contempt, to talk about matters that were done in the grand jury anyway, it's certainly to publish them by filing a written motion. So if he's going to argue those things in open court, he needs to recognize that there is a provision that directs him that he's subject to contempt for discussing matters in the grand jury.
well, the state can't offensively file a motion in limine that prevents us from presenting a defense, and they went all over the place in trying to say exigent circumstances is defined and limited by procedure 502 of the San Antonio General Manual. But 502 does not define constitutional law, and what's important is that 1.07 subsection A30 defines law, and it defines it as both constitutional and statutory law. So that means that it applies to amendments to the United States Constitution. So any suggestion that we can't talk about Graham v. Connor because it talks about the Fourth Amendment is absurd, because the Fourth Amendment is the Constitution and it is part of the United States. And we have both Graham v. Connor and the case that we are referencing in our judicial notice as interpreting both Constitution and statutory law. And the analysis by Judge Bimperod included an analysis of exigent circumstances. And he stated that there were exigent circumstances that justified the officers in using force. So to have them say there was no exigent circumstances and you can't bring up Graham v. Connor is going to hamstring us to rebut that by showing that there were exigent circumstances that Judge Bimperod referred to. So that's also important. And it's important because in counsel's argument, he referenced Article 14.05 of the Code of Criminal Procedure, and what he does is he misstates what exigent circumstances are and tries to suggest that it's constrained and defined only by Procedure 502 as opposed to federal law that defines what exigent circumstances are. And I know that I objected to their referencing what the first officers did, but they are misrepresenting to the court what the first officer did. Officer Ramos tried to kick the door at 49:22, and we see that several times. He tried to kick the door so hard that his body camera fell off, and 3 more times people tried to kick the door, and Ramos told the deceased that they had the right to make entry because, that they had the right to make entry because it was fresh pursuit. So their argument is absurd. And to suggest that there's a different standard between civil law and state law is also absurd, because the reasonableness is what an officer is taught
defense is seeking to kind of argue a federal standard in this trial before this state jury, okay? None of the cases he's talking about, Graham versus O'Connor, have anything to do with the application of state law. And I'll give you an example for that we have, right? The federal laws allow a person or law enforcement introduce a statement in court of a person who is Mirandized without having it be on a recording preceded by the warnings and those kinds of things. Texas can have more restrictive laws than the federal court does, okay? And for us to try this case under federal law, which I can predict right now in the jury charge to this jury, you will not be giving the jury instructions on federal law. Your instructions will come from the Penal Code, the Code of Criminal Procedure, that's based on Texas law and vetted through the Texas Constitution, through the Texas courts. That's what's applicable in this case. For them to try to move this into an arena where they're talking about, well, in federal court, where they resolve this strictly under substantive Fourth Amendment law, use of force, is confusing, misleading, and has no application to this case.
And just to interject, I'm not going to allow any federal law arguments or arguments based on federal law, or let me put it bluntly, quotes of federal case law to this jury during this trial. So that's off the table.
Okay, and so the admission of a federal judgment that cites their reasons for dismissing a lawsuit under federal law has no application to this case. We'd ask that that be kept out.
Yes, and the court would keep out, again, the court would keep out any arguments related to federal court rulings like that, or federal court case law. That would not be a part of this evidence.
Judge, I have to inquire, and I don't want to be contrary, but are you going to prevent us from talking about the training they received in the academy and in TCOL approved courses?
That's not what I said. Right? That was not related to what I just said right now.
Okay,
I'm talking specifically instructing this jury or telling this jury what federal case law is or what Supreme Court case law states.
Okay, so
That's
jury
different.
instructions, that's not going to come in, but what about in terms of the presentation of evidence?
The presentation of evidence is, if it follows the rules in accordance with how the law allows us to present evidence to the jury, then of course, all that. That's not going to be prohibited. I'm just talking about telling this jury what Supreme Court case law states. That's all I'm saying.
Okay, and, all right, I have another question, but I'll reserve that for the judicial notice.
And Your Honor, by our motion in limine, we're not saying that it can't be instructive that officers and their experts testify that these kinds of things are discussed and trained with officers.
Right.
We're talking about it not being controlling.
Right.
And we don't want any kind of insinuation that it's controlling with any of their witnesses that they call, because it's not.
Your Honor, may I just put something on the record just so it's
Yes.
clear what some of our arguments are? Number one, with regard to Graham v. Connor, with all due respect, the state is speaking out of both sides of their mouth. During the course of the litigation, they gave us notice of an expert by the name of Chuck Joyner. They provided us his report. His report, and we can provide it for the court, is replete with Graham v. Connor. That is all he talks about. He says these are the guiding principles that every police officer in this country are trained by. And he only talks about Graham v. Connor. He also goes on to say, you know, according to the precedent of the Supreme Court and this type of litigation, you can't even get into what happened except for the moment that deadly force was used. He talks about that, and if they don't want to call him, that is an admission of a party opponent because he was an agent of theirs during the course of the litigation, so that would be admissible. But even more important, under due process and under our Sixth Amendment right to compulsory process and their duty to see that justice is done, I don't see how they can get away with saying we can't talk about this, and yet their own expert, that is all he talked about. It is completely disingenuous. Now, with regard to the federal opinion, they keep talking about the distinction between a statute. Mr. Harris was talking about 14.05. They haven't talked about the United States Constitution, which completely controls all all of this, and the Texas Constitution, they act like there's this huge demarcation between the Fourth Amendment and Texas law when Mr. Lunan, when he was talking about the Payton case, started talking about the Fourth Amendment. The use of the Fourth Amendment. The Fourth Amendment those are the guidelines or the bumper rails for what happens within the state of Texas. It would be a complete miscarriage of justice if these men were to be convicted in this court after a federal magistrate and a federal judge in the Western District of Texas looked at the videos in this case and said there were exigent circumstances and that the police officer's use of deadly force was reasonable. It is exactly the same issues that we have in this case. Collateral estoppel should argue that they should be stopped from even arguing this because that was judged under a lesser standard. They're going to ask this jury to convict these men beyond a reasonable doubt when we have a written opinion from a federal district court saying their actions were reasonable after watching the videos in this case, which are going to be shown to this jury. Now, besides our due process rights, under the Sixth Amendment, the compulsory process clause, our right to a defense, our right to present our defense, that federal decision is integral. Graham v. Connor is integral, and it's begged to be introduced by their own expert and his written report that Mr. Harris provided us in litigation. But Chambers v. Mississippi, I think Rott v. Arkansas, Crane v. Kentucky, there's 5 or 6 Supreme Court decisions on point that talk about our right to a defense under the compulsory process clause supersedes any state statute or rules of evidence because it directly implicates our rights under the compulsory process clause. We can provide the court with all of those. They should have been cited, hopefully, in some of these motions filed. But I just wanted to make the court aware that the state is speaking out of both sides of their mouth in regard to Graham v. Connor, and then acting like, oh, well, what this federal judge decided is totally divorced from what we're trying to do. The federal judge said these men acted reasonably. They used their use of deadly force was reasonable, and that exigent circumstances applied. So we're asking the court to admit that opinion and to take judicial notice of it. It's not binding. It's not binding, certainly, on the jury. But for us not to be allowed to talk about a federal decision, because obviously the federal decision was the one by Judge Berry, and the other federal decision is Graham v. Connor. That's a federal decision, and their own expert uses all of the quotes, the important quotes out of that case in his report. It's on every page, and he says specifically, this is controlling. In any kind of case like this is controlling.
Just to put a cap on it from us, Your Honor. The federal court had, there is nothing in the federal opinion that addresses the authority of police officers to be in that location and the ability of them to go into a residence against a person they didn't have an exigency for, who did not consent, and that they did not have a warrant. Not addressed in that opinion whatsoever, because it isn't an issue of federal law. That federal law had nothing to do with evaluating this officer's conduct under state law as far whether they even had the authority to arrest her, given those circumstances, and whether she was acting lawfully in protecting her property against people who were unlawfully acting to go in. These are issues that weren't even addressed in that opinion, which shows you the outrageousness of comparing the two, the apples and oranges of the two. State law controls in this case. State law will be instructed by the court. State law has to be approved and endorsed by the U.S. Constitution, the Texas Constitution, and it has. And those laws should be given to the jury, and the jury shouldn't be confused by saying in Idaho this is the way we handle it, in Florida this is the way we handle it, in federal court this is how we handle part of it. Anyway, that's all I would say.
All right. Anything else on that? All right, so I'll take that issue under advisement. What else we got?
Judge, I'll go next. Again, an additional motion in limine on behalf of all defendants filed by Alfred Flores that has to do with some entries for, from his IA file.
Okay.
Included them in the motion.
Is that the Alfred Flores III motion in limine? It starts off with number 1, extraneous allegations?
Yes, sir.
Okay,
That's the one.
okay.
So, in sum, the meat of the motion, extraneous offenses, both general and specific, is that they be ruled excluded until the state is able to prove to the court that it's relevant, that it's admissible, things like his approval will be beyond a reasonable doubt, et cetera. So we would ask that the court grant the motion in limine of the content requested, excluding it until such time as the state feels it becomes relevant, and then we can approach and discuss at that point.
And you know, we agree to most of that, okay? Everything he's got on there except, he's got on, what is it, page 4, where it has the miscellaneous provisions that he's seeking to eliminate out. We would agree to what we provided 404B3707 notice on, those excerpts that you have in your motion. We agree not to bring those up without approaching the bench and showing their relevance, and their admissibility and authentication. With respect to the other 4 items, it's really 3 items, but we agree on to number 2. On number 3, we agreed to call the defendant either the defendant or his name or the accused, any one of those we will, but we won't call him anything but those 3. And as to item number 4, we would object to not being able to refer to the victim. Melissa Perez is the victim, and I've got a case to give you to review on that issue.
All right, so just off the top, then I'll grant the defense filed motion in limine through the number 2 miscellaneous and the 4 provisions there. The state is also agreeing to 2.2 under that
Yes.
miscellaneous, so I will grant the motion in limine on number 2. You guys, you have a response on 1, 3, and 4?
Mr. Lunan, are you saying you're agreeing to 3 or not agreeing to 3? It means
I'm not
that you
sure.
What I heard, this is what I heard. I heard he's agreeing to 3, other than the fact that he may refer to the defendants as a defendant.
Correct.
That's the objection.
Right.
Don't label Alfred the defendant. We call him by his legal name or the accused, but don't label him the defendant.
I don't know of any authority that prohibits the state from doing that, if you can cite any.
Okay. Let's move on to the other.
It's a prejudicial argument. I'm asking you to do a balancing test. It's a prejudicial argument. It's clearly a label. State prosecutors make a good living slinging that label, and so I don't have to make all the arguments. It's prejudicial, and so we're asking they use his name or the accused, not the defendant.
Okay, I'll conduct a 403 on that issue. Let's go.
Similar request on 4, not refer to her as a victim. That's a loaded word. They can call her by her legal name, Melissa Perez, or deceased.
Can I approach Your Honor and give you a case?
Yes.
J. Cox versus State here. And it talks about the defense objecting to the prosecution calling the complaining witness victim. And the court says that's hardly harmful. The jury is going to expect that from the state who's an advocate. It's not error.
Okay.
There is a pretty high standard. We're again just saying it's more prejudicial than probative, and we're asking the court to exclude that label.
Okay. So I'll conduct a 403 on that as well. Let's go to number 1.
last one would just be before, essentially getting into character evidence, as we discussed before, we don't approach the bench, should it become relevant, and have a pretrial hearing before we fire off the witness.
And we would agree to that.
Okay, so then I'll grant the motion in limine under number 1. All right, so let's put this one aside for a bit. Let's go to any other motions in limine that you have.
We have a motion in limine in Eleazar's case.
All right, and this is the one that starts off number 1, the subjects are as follows, any reference to the Castle Doctrine? Is that the one?
Yes.
Okay, let's go ahead and take up this one.
So number 1, the Castle Doctrine has been rejected by the Texas Court of Criminal Appeals as applied to peace officers. There is no way that a Castle Doctrine can be applied to a peace officer. And also, we know that under section 38.03B of the Texas Penal Code, a citizen does not have the right to resist an arrest, whether it's legal or illegal. So to suggest that she had the right to use deadly force against the officers is absurd and a misstatement of the law. What we anticipate is that they're going to talk about her mental health being an issue. And if she was mentally ill and was going to be emergency detained or should have been emergency detained, there's no way that she could have a reasonable belief under Chapter 9 of the Texas Penal Code. And therefore, they can't even lay the predicate for the Castle Doctrine, even if our clients were not police officers. So we'd ask that any reference to the Castle Doctrine or any reference to that the complainant had the right to resist the arrest be forbidden.
May I respond?
Yes.
Remember, the Castle Doctrine is not in the penal code, but it has a kind of a life of its own in what people's understanding is about a person's right to protect their property. I intend to spend a good day of jury selection talking about people's feelings about that term and about the law that incorporated it in Texas, which is section 941, 942 of the Texas Penal Code. And it's important because the defense is asserting a defense of self-defense, and they're claiming that under Texas law that they had a right to use force and deadly force against Melissa and Perez back in June of 2023, June 23rd, 2023. And by raising that defense, in that defense, it says a person went into the degree they have a reasonable belief that they're confronted with unlawful deadly force, they can use deadly force against that person. Well, the jury needs to be instructed on what the term unlawful force is. And again, I've got case law here too, Your Honor. For the jury to understand from Melissa Perez's position whether or not she was acting unlawfully. And under 941 of the Texas Penal Code, known or incorporated as the Castle Doctrine, it says a person in possession, lawful possession of land or tangible movable property is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to prevent or terminate the other's trespass on the land or unlawful interference with the property. And why it's important for the jury to hear this and be instructed on it, ultimately in the jury charge, is for them to understand, under the Castle Doctrine, that a person in their home have a right to resist and use force against an officer who is unlawfully trying to enter their home or interfere with their property. And it's here in the statute. It is founded in our statute here. It's tethered to the Constitution that a person has a right in their home to use force against an unlawful entry. Even by the police, Your Honor. Even by the police. If the police are acting unlawfully and trying to enter a person's property, then she has a right under this provision, under the Castle Doctrine, to use force against them, if not deadly force, under 9.42, if the officers are engaged in criminal mischief at nighttime. So, yes, the needs to hear about whether or not she's acting unlawfully or not when they fire at her 15 times in behind her apartment, secure in her apartment, exercising her constitutional rights under the castle doctrine. So yes, we would object to any motion in limine where we have to approach every time we're going to talk about that, because that's basically the entire case.
So, the state's argument is misplaced for a couple of reasons. Number one, there's the case of County of Los Angeles, California versus Mendez, which is a Supreme Court case, 581 U.S. 420, decided in 2017. And essentially, what they're attempting to assert is the provocation rule. And the Supreme Court specifically rejected application of the provocation rule, which the Ninth Circuit improvidently applied. And the recent federal Supreme Court opinion, Lawrence v. Felix, which Judge Bimperod cited, also rejected, saying that the provocation rule is still in place and that you still go by the totality of the circumstances. Now, in addition, there's I will find it, but there's a Court of Criminal Appeals decision, I believe it's Mays, where an individual was mentally ill and the appellant tried to argue that the appellant had the right to resist the arrest of officers. And the judge in that case said they're not going to adopt any application of the castle doctrine that allows citizens to shoot or kill police officers. So by suggesting that her mental state of mind was relevant to the officer's state of mind is a miscarriage of justice in the improper application of Chapter 9, because Chapter 9 goes to the state of mind of the accused. The apparent belief of the deceased is not the issue. It's of the accused under Chapter 9. And so they're going to improperly shift the burden of proof for the defendants and make our ability to present a defense much higher and much more difficult, and that would be an unconstitutional violation of the law. They have to disprove our client's reasonable belief, and they can't do it by having her subjective belief presented. So for that reason, and I'll defer to my co-counsel here, but for that reason, this argument must fail.
I disagree with Mr. Cifuentes. Your Honor, and I have case law in support of this issue of the victim's belief being relevant in a situation where they claim self-defense. They're claiming in self-defense that the victim is acting unlawfully against them in order for them to use force, that the jury should be instructed about whether or not her conduct is lawful or unlawful, about what the laws are surrounding it. In this case, it's right to protect property, right? That's provided under Section 941 and 942. I'll just say it for the record here. Court of Criminal Appeals case, Donald Witt Bennett versus State, 726 Southwest 2nd 32, and reiterated in a case called Dexter Black versus State from this year out in the Fort Worth. Yes, out of the Court of Appeals in Fort Worth. Now I'll provide these to the judge to review as well. So this notion of the defendant being able to claim self-defense and the state then not being able to rebut that claim, showing the lawfulness of her actions, and asking jurors, particularly in jury selections, how they feel about a person's right to protect their property is extremely important, relevant, and critical to the resolution of this case. And with this cite to, again, the California case, and federal court has no application to Texas laws under 941 and 942.
Judge, I'm actually shocked that the state is in a straight face making an argument for someone that you're not going to hear evidence that these officers drew a weapon on the deceased first. You're going to hear evidence of the opposite. She came at them with a hammer. And for the state with a straight face to make an argument of defense of property because law enforcement is lawfully there, and that's going to be a jury issue. I mean, I'm actually shocked, and I'm gonna bring that defense up with other clients we have, so I'll remind you of that, Mr. Lunan. But to make that argument with a straight face is absurd. It is absurd, as Mr. Cifuentes said. And to present that to a jury during voir dire is gonna open the door now to that federal case. Now, you wanna keep that federal case out because the judge knew that. We're not talking about federal statute versus state statute. It's a standard that they're making a reasonable person standard from the position of the officer. The judge saw everything. There was nothing held back from the judge that was misleading, whether it was unintentional. I know Mr. Lunan, so I'm going to assume it was unintentional. And the judge made an assessment. It was reasonable. And then to say that they had a right to defend, what property was she defending? She had committed 6 aggravated assaults against public servants. Nobody drew a weapon against her. She drew a hammer on them. And so to put that to a jury during jury selection, I mean, give me 3 hours to voir dire this jury judge. And then, but it's an inappropriate argument, and it's misleading the jury judge before they're even sat.
And Judge, I just want to say once again, short-term memory, I guess, because their own expert, Chuck Joyner, they gave us in discovery his report. He says this was a legal arrest. Your own expert, this was a legal arrest. If you don't want to call him, then we can put that report in as an admission of a party opponent by an agent. For them to be arguing and getting so indignant about all of this when their own expert said, oh, this is all controlled by Graham v. Connor. And by the way, this was a legal arrest. And the precedent that Mr. Lunan's just arguing, I don't think any police department is going to like the fact that now the state is saying, the doors are open. Anytime somebody wants to say, oh, those police officers who are trying to arrest me, I can use force, I can use deadly force against them if in my mind they're violating my rights. And Mr. Lunan talked about the 15 shots in Melissa Perez, but as Mr. LaHood pointed out, he conveniently ignores the 3 aggravated assaults on 3 different police officers before that, where she came within inches of striking them in the head with a hammer. And Mr. Harris also conveniently leaves out, when he talks about exigency, hot pursuit. And some of their own experts, and we're going to get into this about San Antonio Police Department personnel who won't talk to us, and why, but some of their own San Antonio Police Department experts have informed them and the chain of command that this was exigent circumstances. This was legitimate hot pursuit. So for these guys to be arguing it's Officer McDonald, Mr. Harris, is completely unjust and a violation of due process.
Your Honor, the law is the law. I presented you with the law, okay? It makes perfect sense for everyone here. If you're in your home and someone is violating the black letter law and trying to enter your home without legal authority that's prescribed in the law about what officers can do and when they can enter and when they can enter without a warrant, and it's in violation of that, a citizen has a right to use force, even deadly force, to protect themselves from that unlawful entry. Has nothing to do with resisting arrest. They can't use force to resist an unlawful arrest, but they can use force, even deadly force, to resist someone from going into their property unlawfully. And that's the theory. They may not like it, and they may know the facts, and they may not like the way that the state can prove that, but it doesn't mean handcuff the state and don't allow them to do so. That's absurd.
So, I'll give you the cases. Great House versus State. It says basically that the Castle Doctrine does not apply to resisting arrest. And that's what she was doing. She was resisting arrest. And then there's the case of Evans versus State. It's 876 Southwest 2nd, 459. The legality of the arrest is not relevant to the defensive issue of self-defense. And in White v. State, 601 Southwest 2nd, 364, the court said the proper venue for challenging the legality of an arrest is in court, not through physical resistance during the arrest. And in Tucker v. State, 114 Southwest 3rd, 718, the court held that the legality of an arrest is not a defense to resisting arrest. So the case law is replete with black letter law that you cannot legally resist an arrest and kill a police officer. And I will try to find that case of Mays versus State. It's a decision in dicta that it was a Court of Criminal Appeals decision that said that they are not going to extend the Castle Doctrine to giving an insane person the right to kill a police officer if they think that the arrest is unlawful. I'll find that for the court shortly, I hope.
I'll have it, I'll provide it to the court, because those facts are in opposite of this case, because it was a clear exigent circumstance case, where the guy is shooting at people, threatening to kill his wife when the police come onto his property to arrest him. Different facts, you're welcome to look at it, you don't need to look up the site.
Are we arguing the
Just
law?
the Castle Doctrine.
But are we arguing the Castle Doctrine as it relates to the jury charge, or?
Motion in limine.
Okay, I got you. All right. I mean, while we're making this argument, let me jump back to the last motion in limine, all right? The one that was filed by Alfred Flores. I've conducted a 403 analysis on miscellaneous number 2, subsection 3s and 4, so I'll just kind of read them so y'all know which one I'm talking about. Number 3 reads as follows: the defendant requests the court to instruct the prosecuting attorney and his assistants not to engage in any name calling of the defendant, but rather refer to him by his legal name or the accused. After conducting a 403 analysis, I will deny that request and allow the state to refer to the defendants as defendants. Number 4, the defendant requests this court to instruct the prosecuting attorney and his assistants not to engage in any name calling of Melissa Perez as victim, but rather refer to her by her name or as the deceased. I will grant that motion in limine. All right, so that resolves that one. Let's go back to this.
So, and there's no way that they can approve that the Castle Doctrine applies, because any way of proving that would be, they can't do that because the person to prove it can't testify in court, and they can't say that there's an exception to the hearsay rule. And it goes back to Judge Bemperod's ruling that it was legal what they did. And despite the fact that Mr. Lunan wants to suggest that Judge Bemperod didn't conduct an analysis of exigency, he did. And what Judge Bemperod did in his opinion and his report, he stated that my client stated when he was aware of an invalid person being inside the residence, that he said, we don't have a choice, we have to go in now. I mean, we have to go in, we have to make the arrest. And Judge Bemperod stated that statement and the facts that my client was relying upon justified the exigency. So, the Castle Doctrine doesn't apply, shouldn't apply. We're asking that before they reference the Castle Doctrine or reference any right to resist, that they approach the court first.
And if we're gonna do that, we're approaching the court now, Your Honor, because we're gonna go into it heavily in jury selection.
That's the issue, Judge. I mean, so then now we have to correct that misimpression. I mean, is Mr. Lunan and the state saying that if Ms. Perez would have completed her objective of hitting one of the officers in the head, specifically Mr. Villalobos, our client, that they wouldn't have charged her with capital murder? Is that what you're saying? Of course they would have charged her with capital murder. Because he's saying that she had justified use of that force. They wouldn't have charged her with capital murder. Hit him in the head, he dies, you wouldn't have charged him with capital murder? He would have. They absolutely would have. So it's disingenuous to make this argument on Castle Doctrine. And Judge, if they have to voir dire on it, then we have to spend even more time correcting that. And then now we're going to be litigating the Castle Doctrine. It's going to turn into a classroom law exam presentation instead of us trying this case to the 12 people that end up being on this jury. It's inappropriate. They've never made this argument before. I've never heard it before between these two gentlemen, and I've worked with both of them. And I know that it's not the standard they want to set for that community out there with law enforcement.
And the cases that we cite are Mays versus State, 318 Southwest 3rd, 368, and County of Los Angeles, California versus Mendez, which is a Supreme Court decision. I have copies of those cases.
Okay,
Now approach.
yes. All right, anything else on this issue?
No,
We do have other matters on our motion in limine. The character of the defendant, and of course, any reference of the arrest of the complainant was illegal, because that's simply not true. What Judge Wimperot determined was that there were 2 prior assaults of peace officers that were committed within the view of peace officers, and under 14.01 of the CCP, the officers had the right to make a felony arrest for the complainant's felony assaults on a peace officer. She threw a candle at another officer before the defendants used any force. So they had the right to arrest her for those felony offenses. And they also had a right to arrest her under Article 14.03A6 because she confessed to having committed a felony criminal mischief. In addition, their evidence shows that the first officer on scene articulated and had evidence from a credible, reliable person, Lieutenant Hudson, that Officer Rojas had a basis to making an emergency detention because Melissa Perez was a danger to herself and others by virtue of the fact that she destroyed a fire alarm system and was paranoid and showed signs of mental illness, and she confessed to the offense. And one of the officers said that he was going to emergency detain her. So the detention was not illegal. The arrest was not illegal. So we would ask that any reference to the arrest of the complainant being illegal not be discussed without first approaching the bench.
this kind of goes in line with what we were talking about before. The defense fails to recognize the difference between the authority to make an arrest, and even an unlawful arrest, compared to the entering a person's property. And although, again, I'll repeat as he said, if she was not in her home and they were attempting to make arrest of her and they didn't have good grounds and it was unlawful, she has no right to resist unless they use greater force if necessary. But in this situation, she's not attempted to be arrested. She's not attempted to be arrested until she's been back in her home for 77 minutes, however long it is. And so the state intends, based on the facts that we've been kind of telling you back and forth here, to assert that it's a question for the jury whether or not she had a right to use force to prevent officers from entering her apartment without a warrant, without an exigency, without her consent, as required by 1405. So, yes, we don't want to have to approach every time we ask officers to confirm that they did not have a right to enter her property and arrest her, given the fact that she was inside her home. Inside her home. And so this is a question for the jury to answer. It's not an issue where the defense wants to preclude the state from being able to admit any evidence or any testimony of that because it hurts their claim of self-defense.
Your Honor, this is going to get into an issue of, this is not an issue for the jury. This is black letter law. When a felony is committed in the presence of a police officer, you don't need consent. That gives you the right to go in. You can enter without a warrant. That is black letter law. For these men, yes, when there were several felonies committed in the presence of several police officers, they have the right to go in after her to arrest her. And when their own how they can get away from their own expert saying this was a legal arrest. This was a legal arrest. You know, as much as they want to deny that, their own expert, who they have the whole country to go out and look for. And this is the opinion that's brought back to them, And now they want to tell the court, oh, that expert was wrong.
Your Honor, that expert that we consulted with was wrong. We have several experts that will give the opposite conclusion than that, okay? But that doesn't make him an agent of the state. The fact that we consulted somebody and they gave an opinion that we disagree with. We provided this disclosure to the defense, obviously, right? But to say that this is an endorsed statement from the state is ridiculous. He knows better.
No, Judge, I will provide several cases. That's exactly what an agent of the state is. That is exactly what it is. It wasn't a disclosure. It was a report. It wasn't like a Brady disclosure. You gave it Mr. Harris gave it in the form of a report. This is what our expert's going to testify to.
Now, he's saying that their expert was wrong. This is the first time we're hearing them admit that their expert was wrong. I would say that's a blatant Brady violation, that they had a duty to tell us that they believe that their expert was wrong, and they should have been told that way ahead of time, and they should tell us what experts they're relying upon now to prove that it's legal. I think this is a blatant Brady violation, their duty to disclose. But I think that what's more important is they forget the fact that under 1405, the analysis of all the cases by the Texas Court of Criminal Appeals says that if you have the basis to do a warrantless arrest, even if someone's in their home, if there's exigent circumstances, you can make the arrest. And they're still wanting to ignore Judge Benferod's review of the body camera, my client's body camera, where he says, oh my gosh, he said some other words, there's an invalid in the house, we have to go in. And that was, in Judge Benferod's mind, sufficient to satisfy the exigent circumstances that's under 1405. And what they're also failing to tell you is that the first officer, before she went into the residence, articulated several times to several people on scene that he was going to emergency detain the subject.
Your Honor, don't have to remind the court of the ethical duties and the duties under Brady. For these gentlemen to just now tell us now that the expert is wrong, I can't think of a bigger Brady violation, not to mention the duty to the court and to opposing counsel of fair dealing and being above board. For them to, and I've been talking about their expert for I don't know how long, and so now finally at the last second, Mr. Lunan says, oh, by the way, we're not going to use him. We don't believe in that opinion anymore. That wasn't a disclosure. This is just a repeated example of Brady violations coming from that office.
And the Brady violation should be a basis for you to grant the motion in limine on respect to this issue as a sanction for their failure to fulfill their ethical duties.
Your Honor, our beliefs and our strategy is not Brady. It's not Brady. It has nothing to do with Brady. We have not sponsored somebody. We have not put somebody on with a particular opinion that we don't believe is true. Okay? The fact that we've interviewed somebody and they gave us a report of their opinion and we provided it to them, and our theory is in opposite of that. I'll say this expert says that the shooting was unjustified. Okay? But that has nothing to do with the Brady violation. And to characterize that as such is desperation.
Your Honor, then I guess Mr. Lunan doesn't know what Brady is. It's exculpatory, which that expert gave exculpatory information, which they're denying. It's impeaching. You're supposed to tell us. It's impeaching. You didn't tell us that he was wrong. You didn't say he was wrong.
Hold on a second. Hold on.
Oh my God.
I never want to interject, but
and
hold on.
It's mitigating. It's all three.
Yeah, we got to make sure that the court reporter can get a record. So let's just not interrupt, right?
We would ask that the Joiner's report be introduced as a court exhibit under seal, and in the event that there's an appeal in this case. And so we would request permission to introduce that under seal as a court exhibit.
Okay. Any response, Dave, with that?
I don't have a copy of it on hand. They have one. They want to introduce it. I have no objection to that whatsoever.
Okay, well, we will admit that, and when you get to call it what you need to call it, we'll call it, we'll admit it, and we'll make it a court's exhibit. Anything else?
Yes, we also include in our motion in limine an attempt to prove that any defense witness, including the defendant or defendants, has a bad reputation, and any reference to any of the defendants being involved in a prior officer-involved shooting, critical incident, or placed on administrative duty or leave by the San Antonio Police Department. And here's an important request as well, the second to the last one, is any reference to the defendant's Garrity statement, Garrity v. New Jersey, that was given to Internal Affairs. The city attorney produced to the court the entire IA file, and somehow or another the state got a copy of that IA file in its entirety, including those Garrity statements. We asked that the state not reference any of the Garrity statements or attempt to question any witnesses from the Garrity statements, because that's a violation of the Fifth Amendment and would be basis for reversal if they were. And any conduct by the defendants being unreasonable because the conduct was contrary to the San Antonio Police Department policy. And this is important because this may sound rudimentary and silly, but it's basic civics lesson. Only the legislature can pass a bill, and only the governor can sign it into law. And the state legislature has not delegated any authority to the chief of police, the city council, or city manager to alter or amend any defense under Chapter 9. So by, the reasonableness has to be uniform throughout the state. It can't be what's reasonable in San Antonio, what's reasonable in Houston, because every police department is going to have a different policy. And in fact, SAPD procedure 501.07 basically says that when you're faced with the moment of truth, when someone is threatened with deadly force, you can use any means necessary to defend that person. So by any means necessary, in essence, means disregarding any prior violation of policy, and it also is contrary to that Supreme Court case I cited to you that talks about how they've explicitly rejected officer-created danger.
With respect to the remaining issues on the defendant's motion in limine, we agree to the motion in limine as it asks for us to approach before offering any rebuttal evidence concerning the character of the defendant. We agree that we approach before offering any evidence of any attempt by the state to prove that the defense witnesses, including the defendant, had a bad reputation or bad character. We agree to approach, seek a ruling before the state introduces any testimony in reference to any of the defendants being involved in a prior officer shooting, critical incident, or placed on administrative duty or leave by the San Antonio Police Department. We agree to approach before offering any testimony, and we won't offer any testimony in reference to the defendant's San Antonio Police Department statements protected by Garrity versus New Jersey. We won't go into that at all. And we oppose the defense request that we approach the court before we make any reference to the defendant's conduct being unreasonable because it violated San Antonio Police Department policy. And because, Your Honor, the state is clearly choosing to use and rely upon the defense of self-defense, that in arguing self-defense and the state rebutting their claim of self-defense, the state has to rebut this thing that the actor was acting reasonably. And it subjective and objective standards. So part of it is in rebutting whether the officer acted reasonable in using force at the time that he did. It's important for the state to be able to bring up information of the officer had been trained on this issue, okay? The officer had been trained on the issue. And I'm talking about issues that are in the San Antonio Police Department policy that are black letter law, the same things that are in the penal code, right? As far as when they can use force and their authority to arrest and their authority to enter the house. When they coexist in policy with what they are in the penal code, the fact that the officer has been trained on this, initially in the academy and in subsequent in-service trainings, is necessary and part of the state's rebutting the defendant's burden of proof, or our burden of proof, in disproving beyond a reasonable doubt that the defendant's actions were subjectively reasonable. So we object to that, and we intend and hope the court allows us to offer evidence of what the defendant's actual notice was, what their actual training was in the academy and in their in-service training and in their experience as officers regarding what actions they can take and not take.
So then they're okay with Connor, then Graham v. Connor, right, Judge? I mean, how can you have one? You can't have your cake and eat it too. My pop taught me, but that's what they want. They want to talk about. They want to talk about the training in the academy and policy. Policy is not the penal code. Every PD has different policy. One PD, Houston PD, Dallas PD, San Antonio PD. They can talk about the training without calling it a violation of policy. But then I guess they're okay with us talking about Graham v. Connor because that was part of their extensive training as well. The chief said that. Mr. Joyner said that in his report. He made an analysis on that as we talked about extensively in here, Judge. So I'm trying to understand what position they're coming from in the argument they're making.
I'd explained before that I don't object to Granberry versus O'Connor being instructive and part of the training. It's just not conclusive.
Well, neither of the policy.
It's not conclusive on the issues.
One at a time.
Sorry. Same thing, Judge. It's the same argument. It's not conclusive. They want to present the violation of policy as conclusive to rebut their burden. Use the facts. Just use the facts.
When the policy is coexistent with the...
That's all right.
I'm sorry.
That's all right. It's okay. That's okay. All I'm saying is they can argue the facts. I mean, it is what it is, and it's not what it's not, Judge. But they want to label it a violation of policy so they can influence a jury inappropriately. That's what it is. And so we're going to go back and forth about what policy is. But then again, they said we can argue Graham v. O'Connor. We can't mention it. It's not controlling. That's fine, but neither is policy. I mean, I still think that's contradicting themselves in argument.
And Judge, just real briefly, just to dovetail on that, it's against policy to shoot into a moving car theoretically, but it's not against the penal code. I mean, there are instances where policy violations still are legal. So the remedy is administrative, which again is just going to confuse the jury.
Anything?
They're free to cross-examine them. And what I'm talking about is the policies that are coextensive with the penal code, right? The authority of an officer to arrest someone in their home. It's exactly the same as it's stated in the penal code under 1405. The words are exactly the same. And the fact that they've been trained on that as department policy and it's coextensive with what's in the penal code, we shouldn't have to approach every time that we prove that the officer had notice of what the law was because he's been trained on it in his policies.
I want to dovetail on what my co-counsel has said. Violation of policy doesn't prove penal code violation, and therefore, under the relevancy rules of evidence 401, 402, 403, the analysis doesn't flush out. The prejudicial value outweighs its probative value. Whether or not the officer was threatened with deadly force, and whether he believed that the threat of deadly force was capable of causing imminent serious bodily injury or death is what's relevant, not whether or not he did a calculus of what's reasonable or not, or whether because of some alleged bad tactics or officer-created danger that he loses his right to defend himself or someone else. It's absurd if, because of a policy violation, a police officer says, I'm going to get fired if I don't defend my fellow officer's life or a citizen's life or my own, so I'm just going to let somebody get killed. That's not what Chapter 9 of the Texas Penal Code requires or mandates.
right, so on this motion in limine, looking at number one, I'm gonna basically just, for our own purposes, call them one through however they end, starting, number one will be any reference to the Castle Doctrine, and then I'll go down in numerical order. So the first two I'll take under advisement. The last three on this first page, I will grant. Turning the page, the first two at the top of the next page, I'll grant those motions in limine. And then the very last one, making reference to the San Antonio Department policy, the San Antonio PD Department policy, I'll take that under advisement. All right, so that concludes this motion in limine, is that right?
Yes, Your Honor. I'm sorry, with respect to 1, 2, 3, 4, and 5, Your Honor, I'm sorry, I didn't hear.
So it'd be 3, 4, 5, 6, and 7. If we say that there's 8 of them, start at the top and go down 1 through 8.
Now, we don't agree on 4.
But you did not agree to the one.
We do not agree on 4.
Oh, I got you. That's right.
It's really the same argument as the
Yes,
other ones.
yes. No,
Right,
you're.
so we take that under advisement?
Yes,
Okay.
that one, number 4, second under advisement, and I misheard that you had agreed or not agreed. So we will grant, or the court will grant 3, 5, 6, and 7, and 1, 2, 4, and 8 will be taken under advisement. All right. The next one that I have before me, you guys require a break at all? It's because you guys are all young. Except for maybe the. I'll leave it at that. All right, let's go ahead and go to the next one then. I'm looking at one filed by Eleazar Alejandro. City of San Antonio's motion to quash defendant's subpoena duces tecum and motion for protective order. No, this one was filed by the city.
Yes, sir.
Okay, and this one you guys have worked that out already.
There were 2 motions quashed that the city filed. We worked an agreement out regarding both, but with regard to the second one, which relates to the disc that you received today or earlier?
Yeah, today.
Earlier?
Today.
We decided to address that should the need arise based upon the unfolding of the evidence.
Okay, so then when the time comes, it'll be addressed?
Yes, sir.
All right, state, you're okay with that?
I believe the same request for the same information was made by each defense and the state. Am I correct?
I only received 1 subpoena from Mr. Alejandro's attorney.
The state did file a subpoena of their own for the same information.
I'm sorry.
Subsequent to the defense filing, the state did file a subpoena for that exact same information. We just filed a notice last week, so I think it's of interest to both parties.
Yeah, and so let me just throw this out. So this was submitted to the court this morning as it related to the subpoena duces tecum. It's a training course on tactical disengagement. The purpose of providing it to the court was for an in-camera inspection. After consideration, the court is willing to basically give this disc to both sides now.
Judge?
Yes.
The city was, and it's the city's motion, we requested that there be a protective order. So prior to the release, we would like to have the opportunity for a protective order to issue in the event, because these are tactical decisions or tactical information related to police tactics that may not be appropriate for public disclosure in terms of threatening public safety or officers in the event that this material becomes largely publicly available. And so prior to the release under the court's ruling, the city would like to have the opportunity to draft a protective order specifying what may be done with the information and admitting the documents under seal so that they don't become public record.
I'll grant that protective order now. Okay. Submit that order. I'll sign it, and I will provide this DVD. I guess I'll say to the state, and then instruct the state to immediately provide a copy to each of the defendants.
And I don't have an objection to that. Included in the protective order, we would also like that the materials be returned following trial.
Okay, I'll grant that.
Thank you, sir.
All right, state, if you want to obtain this, and if y'all can make copies for each of the defendants,
Thank you.
you're welcome.
And there's one matter that we'd like to bring to the attention of the court that may require Mississippi Ora's attendance, so I'm wondering if we can take that up now for her convenience so she can leave.
let's take it up now for her convenience.
My convenience is here all day, so if you
Ma'am, if you want to come forward, that way we can hear you a little better. That's unrelated to your voice, more related to these ears. So,
You can stand here either way.
Yeah.
All the way up?
yeah, no, either way, yeah, you can come up if you want.
Actually, what I was gonna inform the court is that, we have reason to believe that, a gag order has been imposed on witnesses who are City of San Antonio employees. And we have, Robert Moreno and, Lisa Miller, and actually Andrew, Del Cueto, I believe he's in the 144th. I'm sorry? Okay. Have information relevant to that issue. And if I could outline to the court briefly what I expect their testimony to be, is that earlier this year, Andrew,
However, we would ask if there's going to be some factual representation made in with all the witnesses here, that they be placed under the rule and not be influenced by his presentation of what the facts he says they're going to be, what they're going to say.
All right. Any response to that?
well, this is dealing with, what we're gonna request is we're gonna request that the court issue an order that we can serve to all of our witnesses that we've subpoenaed and contacted, that they should be free to talk to us about whatever they want regarding this case, because we have information that they've been instructed by their supervisors, police officers, witnesses, have been instructed by their supervisors that they cannot talk to the defense. They can only talk to the DA or the city attorney's office. And therefore, people that have promised to call us have refused to call us back because this gag order has been given. And I was gonna establish through these three witnesses the circumstances for why we have that belief. So if the gag order is in place, if you issue an order saying that there is no such thing as a gag order, because the city attorney's office and the police department has no standing to preclude a witness in a criminal case from providing information to the defense, we would like to draft an order that we can send to the witnesses so they know that they're free to talk to us. And I don't know if my co-counsels wish to join in that request. If they have any comments.
Yeah, we have, I mean, obviously, Judge, I mean, this would be unconscionable if anybody, supervisor or from the city, if I'm saying if, they'll let Mr. Cifuentes through witnesses if you want to establish that. Someone's tampering with witnesses so that you can't speak to the defense without city attorneys being there, that's the allegation of this judge. And so, obviously, that's concerning to us. We've been trying to talk to certain witnesses that have expressed to us that they wanted to talk to us, and then they've gone dark on us, and then we hear this information, and it fits. So, we have witnesses to present to the court, that this is a colorable issue we're bringing up. We're not just throwing mud on a wall. It's a colorable issue that we believe can be established through witness testimony, under oath if you want, Judge. And it's very concerning to us, as you can imagine. I'm not saying that anybody's involved or not involved at this time, but I think it needs to be fleshed out because we have witnesses wanted to share information with us and have not shared it with us because they're under some fear of some type of retribution or reaction from the city.
So what I would suggest, we can hear testimony, and I don't want to make accusations publicly if, I know Mrs. Diora, I know she's an honorable person. I don't think she would have any part of that. I've seen her vigorously oppose things that the city has suggested that she believes are unethical. So I don't have any question about her integrity. I'm just asking that we be permitted to draft an order so that when we talk to witnesses, we can tell them that if they want to talk to us, they're free to do so.
All right, and I'll ask the attorney for the city, do you have any response to that?
I have no knowledge of such an order being placed, Judge. My understanding under the law is that a witness has the choice about whether or not to talk to either side. And so I am a little concerned about there being an order put in place because it assumes that there is some impropriety, and I don't have any factual information about this. I worked with Mr. Cifuentes regarding some of his subpoenas that were issued. And so I feel a little bit caught off guard in that no one has raised this issue to us. So I don't even have the opportunity to talk to my clients to see whether or not there's any merit to what they're saying. And so I'm not sure the best way to proceed, except that I don't think that a witness is required to talk to anyone, but I know of no order telling them not to.
All right, so after hearing argument of counsel, I'll allow the defense to draft that order, and I'll grant it.
Thank you.
You're welcome. Does that resolve the city's involvement?
I believe so.
All right.
As long as the order doesn't say that you have to talk to them, but that they have that choice.
Correct. That there is no gag order that prevents them from speaking to them at their discretion.
We don't have any disagreement with that.
Okay. All right, we've been working our court reporter hard. It's 3:20. Let's take a short 10, 15-minute break, and then we'll continue on. gonna have to bring in a cut man for this trial. We gotta bring in a cut man.
I got a couple Band-Aids.
All right, whenever you're ready. All right. All right, we're back on the record. State versus Nathaniel Villalobos, Eleazar Alejandro, and Alfred Flores. We're in the middle of our pretrial hearing. I think we went through those. Let me see. I have the others in electronic format. I have one that is. Let me see. Well, y'all tell me. Are there? You guys tell me which ones y'all are.
Your Honor, there is a motion in limine, also filed by the state in the A case back on April 29th, 2024. It specifically regards the background and arrest history of Melissa Perez.
Okay, I don't have that one. I could either ask the clerk to come out. Yes.
To facilitate, Judge, copies were, in the A case, was originally filed and served in the district court on April 29th of 2024. And I noticed just last night, an oversight, it was missing on the B and C cases. Those were e-filed last night, and I emailed counsel before I came to this proceeding, copies in each respective case. In convenience, if I could just proceed forward, but I believe you all have it now, and you said you adopted all. You have a hard copy? Yes. Yeah, it's nothing major, what we have, Judge, simply her criminal record that preceded June 23rd, 2023 has been provided in discovery, and we're simply asking if any time with any witness, because no one knew her before June 23rd of 23, that before anyone elicits its testimony about any acts, any prior arrests, that they approach first and establish relevance before they proceed. It is all it's simply asking, routine motion.
I think that's fine, Judge, as long as we're allowed to argue 404A2 and 405B at the appropriate time. Of course, the relevancy under 401 and 402, and we can do a 403 balancing test at that time. That's fine, Judge. We'll approach it.
Well, to the extent that it references knowledge by Vince Gomez, we would object to that because Vince Gomez arrested the complainant on April 1st of 2023 without incident, and she was cooperative then. In addition, I believe that Jay Salinas said that 2 weeks before this incident, that he had an encounter with her, and to the extent that we're precluded from talking about Jay Salinas, who had knowledge of her beforehand, I don't think that this motion is proper.
And Judge, we would also add in, there's some witnesses from the apartment complex that had knowledge of her and had dealt with her before, so same position that Mr. Smith is in.
And also, my client had knowledge of her involved in an incident where she used a bat to destroy mailboxes before this.
Okay. It's a motion in limine.
Yes, sir.
I'll grant it. If y'all want to approach any time, approach, and we'll go over the issues that have already been discussed.
So, I understand the court's ruling is that you're granting the motion, but this motion doesn't reference the cases that we spoke about concerning. Do you want us to approach anyway?
Well, if it's not in this motion, I'm not taking it up.
Okay,
So you know.
so we're free to talk about any case that's not in the motion, is that correct?
As far as I'm concerned, as it relates to the motion in limine, that's what we're focused on. If you want to talk about other issues that would require a 404 type argument, right, an analysis, we got to take it up when that time comes.
Your Honor, and then towards that, item 10 in the motion, allegations Melissa Perez damaged mailboxes at the Nana Apartments on or about 16 February 2022. Is there incited? I believe the prior arrest of Gomez executed a month before. I know it was disclosed in notice, and yeah, May 14th, that's item number 2 in the motion. As for any unnamed neighbors, I don't have official reports on that. Again, I think it's appropriate that a motion in limine approach to make your arguments and ruling at the time is what's appropriate.
I granted this motion in limine. All right. All right. Any other matters you want to take up?
You know, that's all we have in the way of motions. We do want to talk about some procedural matters. Mr. Nesbitt talked about that they have their own. We want to talk about the prospect of doing a jury questionnaire prior to jury selection tomorrow and incorporating how we might want to do that. We have submitted a proposed jury questionnaire at our last setting. We provided the court with a copy of that. Each of the defendant's attorneys have a copy of that. If we can kind of resolve that issue.
All right.
So, 4.
But I guess what I would first ask, is the court, the 399, going to be structurally and sanitarily available tomorrow for jury selection?
It's my understanding that it will be. It's my understanding also that the clerks of the court have had a significant number of phone calls related to folks wanting to be present, and I'll leave it at that. I mean, it's going to be an open courtroom. We'll do the best that we can to accommodate everybody, obviously, and we will accommodate whoever wants to observe. But as it relates to the sanity, as it relates to whether it's cleaned up, yes, it's my understanding that it should be structurally sound.
Thank you. Do we have a seating chart that is available? I think both sides are curious on that housekeeping issue.
I know that Trish is preparing one. I'm certain that by the time this hearing is concluded, she should have that available for you.
Thank you.
She went down there yesterday and mapped it all out.
Moving next to the jury questionnaire, I think this is going to be our unified position on all 3 defendants. Judge, we're going to object to the use of that questionnaire, and we're going to oppose it.
And I guess the argument that you're going to make is they'll have the ability to do this during their portion of the voir dire.
Yes, and if you take your pen and circle things and cross things out on that page in a hallway away from lawyers who are curious to watch your reactions, your posture, how you behave when you're being asked certain questions, and how your tone and tenor and credibility is in your response, you're depriving us of that. Plus that questionnaire might make what's already going to be a lengthy jury process even longer. I could go on and on, but our position is going to be that we oppose that jury questionnaire. It sounds like voir dire is going to be a place where a lot of issues are brought up and contested based on this hearing. So all the more important to have the lawyers actually discuss those issues and get those opinions in front of live potential veneer women and make those observations in those notes. I think that's all I have for jury selection, Judge.
Our hope is it would save time, Your Honor. I guess it could be argued either way, whether it would save time or not. Does the court have an idea of how much time each side will be allotted?
Well, this would be a good time. Yeah, let's get those housekeeping rules. So, you know, obviously the code reflects 6 peremptories each. Side for the defense, which would then give the state 18, right? So that's clear. So 6 for each defendant, 18 total, 18 for the, and we are going to have 2 alternate jurors. So generally speaking, typically that would be 4. Each side would get a strike. So we'll increase that because each of y'all will have 1 alternate strike, right? Because if you have 2 alternate jurors, at each side gets 1 alternate strike. So then the defense would have 3 alternate strikes. And this, is that right?
They would have 3, and then they would have 1 each.
That's exactly right.
Okay.
So that would be with the alternate strikes. As it relates to voir dire, what kind of time are y'all thinking?
Well, according to Mr. Lunan, maybe 4 hours each, I'm joking. But I mean, I would think, a little bit over an hour, Judge, I think between each of us. Well, yeah,
General and specific.
I'm not saying an hour total, I'm talking about each. Are you talking about, I guess the question that Mr. Norton is saying is, how do you want to do it? Are we doing general and specific at the same time, or are we doing general and then we'll do specific at the bench the way we normally do it?
Everything is all at once. You do general and specific at once, and what you handle that however way you believe. The court should have the ability to rule. Okay, so after you've conducted your voir dire, jury's out in the hallway. Then I think most of you have all tried cases in here, right?
Yes,
So you guys will have your allotted time. Speak to them in whatever manner you want. We'll let them out. If you believe that there are some that need to come back for additional questioning, generally I'm pretty open to that. In this case, I may not be quite as open. I may be a little more strict with that, but you would have that opportunity.
I mean, in a case like this, Judge, I mean, with the media presence and the people's opinions, I mean, I think an hour and a half would be appropriate.
An hour and a half? You're talking about 4.5 hours?
I mean, I'm not saying we're gonna take it. I mean, people claim that I'm a little more verbose than my co-counsels, but I mean, we need time to flesh out issues and see what people think, and if they have any biases or prejudices towards this case and police officers. I'm sure they want to have similar questions about that as well.
I think all sides. I think every attorney in here is kind of loquacious, right? It's not that's not necessarily a.
Well, Your Honor, we just asked for equal time, right? I mean, if they're each gonna get an hour, then we should have 3, and that's the difficulty.
That's a discretionary part of the court, right?
I
So
understand. That's what we feel. I think we're gonna, I don't know, we probably have the most to say. I don't know if that's necessarily true. That's generally the case. But that it not be, we get an hour, they get an hour, they get an hour, they get an hour. We think that would be very unbalanced.
yes. All right. So I'll keep that in mind. You know, there's a consideration related to the time. You know, we had a jury trial 12 years ago, and one of the attorneys in this court was involved with that jury trial. And I think we kept the jury very late, the panel very late during voir dire, and it was not a good circumstance. And I do not want to do that. I do want to conclude the voir dire with that panel, with that jury selected within a very reasonable period of time. I cannot anticipate a panel getting up here before 10. Does that sound about right? They'll be here before 10? Okay. So, I mean, let's pretend worst case scenario we start at 10. I mean, if we're talking 4.5 hours, that's 9 hours of just voir dire. That's not counting the court's time. Because the court, what I always do, and you guys are familiar with this, I tried to remove a lot of the questioning that y'all would do up front to sort of help on the time. So obviously, I don't know if it was a situation where we knew we're talking well over 50-something folks that need to be qualified in order to allow you to exercise your strikes. So if we were to have typically, I think the most we can sit in there is 120. Typically in here, the most we can sit in is 80. There is a possibility we're going to have to bring in a second panel. We have no clue. And if we do that, the court has reserved a panel for tomorrow, and we will reserve one for Friday in case we need to go there. And the way we've set up our jury room now, if we don't need that second panel, we send them a text or an email immediately, so the folks are aware that they are not going to be required to come in. So the way we're talking here, I'm getting the sense that this could even be a 2-day voir dire for one panel. And if that's the case, that's going to be pretty difficult.
And Judge, it's difficult to kind of really gauge, I think, how long we think we need. Understanding the court needs to take certain things under advisement. It depends on, some of those rulings could either shorten or increase the amount of time we would need. So, I mean, once we get that information, we might be able to give you a better, better estimate. I mean, it's still be an estimate.
Yeah, and I'll have that available first thing. Obviously, I got a lot of case law to read.
Yes, sir.
With I mean,
I think, Judge, I'm sorry, Judge.
No,
I can
no.
represent that I don't think everybody's gonna do the same extensive portion of their voir dire on the right to cross-examination or right to remain silent. I mean, I think we can work together, and if they, I mean, they don't have to do it our way or whatever way, they'll have to add little things that they have to, because they have obligations to their clients, but you're not gonna get a complete presentation, a fresh presentation of each issue in voir dire from 3 defense counsel. Does that make sense, Judge?
Yes.
So we can be expedient that way, we can talk, we've already started talking, and we have, of how it's gonna be presented, so I wanna present that to the court as well.
And like I said, as it relates to constitutional issues, the court will provide its own voir dire to hopefully minimize too much of that stuff, in the interest of brevity and time. So let's sort of play it by ear. Let's go ahead and see how the rulings work out in the morning. I know that y'all will work together. We know that the longer the voir dire, the more breaks. We know everybody's got to be here. More breaks are more problematic when you're dealing with a 120 panel. So those are all things to consider. My goal is to conclude an entire voir dire and strikes done at a reasonable time tomorrow, and not extend into a second day. And so I'm going to be focused on that. Beyond that, we'll just play it by ear tomorrow morning.
I had a question, Your Honor. One of my experts would like to attend all the witness testimony, so I'm just wondering what's the soonest date or time you might expect us to start taking testimony?
On Friday?
Yeah, depend on the selection, right?
Yeah, I mean, if we conclude tomorrow, it would be Friday. We would have the whole day Friday, right?
Assuming we're done tomorrow, it'll be 9 o'clock on Friday.
Yeah.
So no testimony will begin Thursday, no matter what?
No.
At midnight.
Right, I was going to say. Yeah.
On midnight.
The first witness will be called at 10:30 p.m. We don't want that. Yeah. Yeah. But I get it. Yeah. So yeah, Monday, as long as we can conclude the entire jury selection process tomorrow, Friday, 9 a.m. we'll begin evidence. Well, at least opening statements.
And if not, Monday at 10:30.
And if not, then Monday we would go at 10:30. I anticipate during the trial we are going to maintain some dockets. I mean, we anticipated a 3-week trial. We don't want to unnecessarily delay justice for every other case that's pending in this court. So we will probably have a very short docket each day in the morning.
And Judge, there's one other thing that we wanted to notice the state. There's a Mr. Angelos Leilaglu, who's an expert in the principles of forensics. He's a forensic analyst on visualization and incident reconstruction. He works with Ron Martinelli, who we've noticed him on before already. He's kind of I don't want to miss their contract worker with him, an expert that works with Ron. And so that'll be part of his presentation, but we wanted to notice them on Mr. I'm going to butcher his name, Leilaglu. Don't try to spell it. Just to and I can get him his CV and all that other stuff on that.
Sounds good.
And I just wanted to make sure that on the motion to take judicial notice, you're taking that under advisement?
That's correct.
Okay.
And Judge, I don't know if you want to do this as we approach off the record, but obviously what's looming in our head is October 17th as well. I think you know what that day is. It's that other trial in another court.
Yes.
I'm sure. I mean, obviously we're more than capable of trying that case. Obviously we can't try 2 cases at the same time. And so I want to be very proactive about this and make sure that we're not waiting until the 16th to address it.
I've talked to the judge about it.
Okay.
So let's the judge and I have come to an agreement in the 437th. So we can definitely address it in the morning. Make sure that your firm can be effective.
Yes, sir. Thank you, Judge.
You're welcome.
Thank you, Judge.
You're welcome.
For now, we need to plan on having witnesses here the 17th, and that may be subject to change, is that?
Let's talk about that in the morning. And let's resolve that issue tomorrow morning, because I do not want to. I do have an agreement with the judge. We have agreed that we're going to allow each other to handle our cases. I think he talked to y'all about potentially picking the jury and then beginning the trial a significant time later. So that's something that we discussed. So in the morning, I'm going to make sure that I'm on the same page with Trish, and then we'll figure that out. In the morning, I'll let you know. Anything else? But I'm not going to get in the way of a voir dire, that's for sure. In that case.
Voir dire for tomorrow or voir
No.
dire for his voir dire?
His voir dire on the 17th. Although I do note that I don't see him here today, so that's,
He's in trial, Judge.
well, there, yes, you know, so,
You talking about Mr. Goss?
yes.
He's in trial in Weatherford County. He'll be here tomorrow.
There you go. All right. Anything else?
What time tomorrow do you want us here?
Like 9:15? No, well, yeah, I just gotta get the rulings. 9?
Oh, you don't.
Just the ruling. Yeah, 9.
9 o'clock?
9 o'clock in the morning tomorrow.
And
In the 399,
399.
yes, in the 399. Unless you wanna meet here and then we can make a show of going down to the 399 together.
We'll have to be down there, so we should be down.
Okay, yeah. Well, I'll be down there. Okay. Anything else? All right. All right, you have a great rest of the day. See you tomorrow at 9. Yeah. Yeah, sounds good. In the doorway. Yeah. We'll make it work. We'll make it work. Mm-hmm. Yeah.
Oh, you did already.
How are you?
Good, how are you?
Good, all right.
I don't know who these all are.
That's it. Yeah, these two belong to the court.
Okay, just want to make sure. How's it going?
He wants to make sure that he can hear me.
So, just so